So here's where things stand under the Trump administration. Along with backing from 25 states, there's now a full-scale legal push against state-level bans on concealed carry permits. This legal battle has officially made its way to the United States Supreme Court, and it looks like one of the states trying to uphold a carry ban may have just undermined its entire position. Let's unpack what went down. But first, if you support Second Amendment content and want to help keep this channel alive, hit that subscribe button. It's free, and it tells the algorithm that you're into pro-freedom content. Leaving a quick supportive comment below also helps push these updates to more folks like us who care about protecting our rights. Now, like I said in the intro, I've got a big update for folks living in places like New York, California, Hawaii, and other anti-carry strongholds. Right now, the case Wolford versus Lopez out of Hawaii is making serious waves. It's seeking emergency review from the Supreme Court after a decision in the Ninth Circuit sided with Hawaii, allowing them to enforce a blanket ban on carrying firearms on so-called public properties, which, if you've read the fine print, is basically everywhere. What caught many people off guard recently is the fact that the Department of Justice, under Attorney General Bondi, is stepping in to support gun owners in this case. They filed an amicus brief with the Supreme Court urging the justices to take up the challenge, stating that these concealed carry restrictions fly in the face of the court's earlier ruling in Brewing. That position has now been backed by 25 pro-Second Amendment states and several major firearm advocacy groups. Hawaii, of course, had to reply, and in their latest filing, the state claimed the Supreme Court doesn't need to weigh in just yet. They argued that the matter still needs to play out in the lower courts, that more facts must be collected, and that a final ruling on the merits hasn't been reached. But here's where things get interesting. The plaintiffs in Wolford called them out, pointing directly to statements Hawaii made earlier in the Ninth Circuit that completely contradict what they're now telling the Supreme Court. In fact, Hawaii's own prior arguments were one of the main reasons the Ninth Circuit sided with them in the first place. So now, it looks like the state's legal position may have just collapsed under its own weight. In case you haven't been following closely, this legal battle targets Hawaii's latest round of concealed carry restrictions, which were crafted directly in response to the Brewing ruling. Just like several other anti-gun states, Hawaii decided to go the opposite direction of what Brewing clearly laid out by passing Act 52. That law created a new framework that basically bans carrying a firearm on most private property that's open to the public, unless the property owner explicitly gives permission. Now for context, Hawaii already had a miserable history when it came to issuing concealed carry permits. Over the course of about 18 years, only a tiny number of permits were ever approved. One county hadn't issued a single permit, zero. So, when Act 52 was pushed through, gun owners and two pro-Second Amendment groups filed suit, taking the state to court. The case was first reviewed by the district court, which issued a temporary restraining order, later upgraded to a preliminary injunction. That lower court ruled that Hawaii's broad restriction on carrying firearms on private property was likely unconstitutional under the Second Amendment, and clearly conflicted with what the Brewing decision laid out. But the case didn't end there. It went up to the Ninth Circuit Court of Appeals, where it was bundled alongside California's own carry ban cases. The three-judge panel on the Ninth Circuit reversed the injunction and sided with Hawaii, saying the catch-all property ban could stand. They leaned heavily on historical laws involving hunting restrictions on private land to try and justify Hawaii's modern carry ban. After that setback, the plaintiffs requested an en banc hearing, basically asking the full Ninth Circuit to revisit and overrule what the panel had decided. That request was denied. However, one notable dissent came from Judge Van Dyke, who blasted his colleagues for once again undermining the Second Amendment and argued that the case deserved further review. All of that brings us to where we are now. The plaintiffs are once again seeking emergency relief from the United States Supreme Court. And here's the challenge, as SCOTUS typically doesn't like stepping into cases that are still at the preliminary injunction stage. There hasn't been a final ruling on the merits yet, and historically, the court has steered clear of early-stage intervention in these kinds of cases. That said, this time around, the case might have more traction because the United States government, under the Trump administration's guidance, has thrown its support behind the challenge. In their amicus brief, the administration stated flat out that Hawaii's near-total carry ban flies directly in the face of Brewing. which recognized the law-abiding citizens' general right to carry a firearm in public for self-defense. What makes this even more interesting is that the brief calls on the Supreme Court to intervene now, despite the fact that the case hasn't reached a final decision. The argument is that Hawaii already told the Ninth Circuit that there was no need for further evidence or development at the trial level. But now they're telling the Supreme Court the opposite, that more fact-finding is needed, and it's too early for high court review. That contradiction is what could sink Hawaii's case entirely. In response, Hawaii's legal team is doing what anti-gun states usually do in these situations. They told the justices that the case is premature, that more proceedings are necessary in the lower courts, and that the Supreme Court should decline to get involved at this time. They also argued that there's no circuit split, meaning there's no major disagreement among the lower courts that the Supreme Court needs to resolve. Interestingly, Hawaii also took aim at the United States government's involvement. They said the federal government's brief was unwelcome and irrelevant, calling it uninvited. Yet, in the very same argument, Hawaii tried to claim that the federal brief's silence on the second legal issue somehow supports their side. So on one hand, they're saying the brief should be ignored, but on the other, they're cherry-picking from it when they think it helps their case. That kind of legal double-speak doesn't play well, especially not with a court that values consistency. At the end of the day, Hawaii's attempt to delay Supreme Court review may have just backfired. The contradictions between what they told the Ninth Circuit and what they're now saying to the Supreme Court could end up blowing their entire argument wide open. This issue was brought front and center in a recent filing submitted by Mr. Wolford. In that brief, he highlights a key inconsistency in Hawaii's position. Specifically, Hawaii is now telling the Supreme Court that the case isn't ready for review because the lower court record supposedly lacks development. But here's the problem. Hawaii previously told the Ninth Circuit the exact opposite. During oral arguments in front of the Ninth Circuit, Judge Schroeder asked Hawaii's legal team a direct question. On the matter of the preliminary injunction, what's left in this case to actually litigate? And Hawaii's counsel responded by saying, word for word, "We think there isn't anything. We believe, ultimately, there are no Second Amendment violations here." That statement was not just casual commentary, it was a legal concession. And under the rules of the court, that kind of admission is binding. In other words, Hawaii went on record in the lower court, saying nothing else needed to be hashed out, no trial, no additional evidence, no findings on the merits. That's the position the Ninth Circuit relied on when it made its ruling. But now, when it's no longer convenient, they're trying to flip the script and tell the Supreme Court that the case needs to be sent back down for more development. That's not just inconsistent, it's a strategic contradiction, and one the plaintiffs aren't letting slide. The brief also calls out another weak point in Hawaii's defense. Their claim that their state's unique history, dating back to 1852, somehow justifies a blanket public property carry ban. Hawaii is trying to argue that its localized tradition of limiting firearms in public spaces should override the national standard recognized in brewing. But the plaintiffs respond forcefully, saying this claim is outright nonsense. They write that Hawaii seriously errs in asserting that its default rule is constitutional simply because it has limited public carry since at least 1852. What Hawaii is really saying is that its local tradition outweighs the founders' intent, and that idea is flat out absurd. So here's the core issue. Hawaii already confirmed in the Ninth Circuit that there was nothing left to be examined at the trial level. That means they cannot now turn around and ask the Supreme Court to delay or avoid review on the grounds that more lower court proceedings are needed. Doing so not only undermines their own prior argument, it also undermines the decision the Ninth Circuit handed them based on that argument. With support from the Trump administration, that contradiction is being brought into the spotlight. What we're looking at here is a situation where Hawaii may have boxed themselves in legally. Their own words from the earlier proceedings are now working against them. The bulk of their new Supreme Court brief is focused on kicking the case back down for more development, but again, they already agreed that development wasn't necessary. We'll have to see how the justices respond to this, but it's clear this case has grown in importance. It's not just about one state's carry restrictions, it's about whether anti-gun states can bend the rules to dodge Supreme Court scrutiny. That's the latest in this high-stakes battle over concealed carry rights, currently sitting before the highest court in the land. As the situation evolves, I'll make sure to keep you all up to date. Thanks as always for tuning in. If you found this breakdown useful, go ahead and hit that like button. Leave a comment down below and subscribe so you don't miss any future updates. And remember, this country was founded by scholars and defenders alike, and it'll take both to preserve the freedoms we hold dear.